Good evening. I hereby announce that pursuant to Section 5 of the Open Public Meetings Act, that adequate notice of this meeting has been provided in the notice which was sent to the Asbury Park Press and the Two River Times and posted on the bulletin board in Township Hall and filed in the Township Clerk's office on May 3rd, 2019. Mayor Hines is not here. Mr. Bontempo?
Here.
Mr. Catelli?
Here.
Dr. Pascucci?
Here.
Deputy Mayor Nicholas?
Here.
Please rise for the Pledge of Allegiance.
I see one of my scouts from Troop 131. Would you want to come forward and lead us in the pledge, please? Are you here for citizenship in the community?
Yeah.
Yeah, come on down. Lead us in the pledge, my friend.
Mike's on.
Valor, how are you? Good. Go ahead.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I would please remain standing so we may honor our police, fire, and EMS who respond to our emergencies, that they may get home safely to their families. Thank you. Okay, I believe we have there's a resolution to go into executive session, but I believe, Mr. Collins, we are not.
That's correct, Deputy Mayor. Thank you, and good evening to you and members of the committee. I'm going to distribute for everyone's benefit up here a document that I prepared. Good evening. The first item on tonight's agenda is a resolution to enter into executive session in part to discuss personnel matters pursuant to NJSA 10:412B8. This exception allows the Township Committee to discuss any, quote, matter involving the employment, appointment, termination of employment, terms and conditions of employment, evaluation of the performance of, promotion, or disciplining of any specific current employee employed by the public body, unless all of the individual employees whose rights could be adversely affected request in writing that the matter or matters be discussed at a public meeting, end quote. In Rice v. Union County Regional High School Board of Education, 155 NJ Super 64, an appellate division decision from 1977, the court held that employees subject to an executive session discussion under the personnel exception whose rights may be adversely affected must be provided with, quote, reasonable advance notice so as to enable them to, 1, make a decision on whether they desire a public discussion, and 2, prepare and present an appropriate request in writing, end quote, for the discussion to take place in public session. This notice, required by the Rice case, is commonly referred to as a Rice notice. In anticipation of tonight's executive session, on May 3rd, 2019, I provided a Rice notice to 2 employees of a proposed discussion which could affect the terms and conditions of their employment. In response, on the morning of May 6th, 2019, today, the Township Committee and I received written responses via email from both employees requesting that tonight's discussion take place in public session. That decision is the right of each of the employees, which we are legally obligated to respect. Therefore, this discussion shall take place in public session. The 2 employees in question that are the subject of this discussion hold the positions of Township Administrator, who will hereafter be referred to as the Administrator, and the Township Human Resources Manager, hereafter referred to as the HR Manager. As we begin, I will caution the committee that this dialogue shall only involve members of the Township Committee and myself, as would be the case in an executive session. I would also note that there are certain aspects relating to what we will discuss tonight that remain subject to the potential litigation exception and/or attorney-client privilege as set forth at NJSA 10:4-12B7. Those items may not be discussed publicly and must instead be discussed in executive session. Finally, because this matter is being discussed in public session, I have prepared a written narrative in order to ensure full factual accuracy and thoroughness for the benefit of the Township Committee, the public, and all affected employees. This matter involves a complaint made by a former Township employee, hereafter complainant, to me. The township's policies and procedures manual, hereafter the manual, provides that, quote, employees who observe actions they believe to constitute workplace wrongdoing should immediately report the matter to their department head, the township administrator, the human resources manager, or the township attorney. The complainant alleged that the recommended hire for a payroll supervisor confidential assistant position, which was placed on a previous township committee agenda, was directly related to the township's HR director, hereafter referred to as the relative, presenting a nepotism issue. The complainant contended that the HR director actively participated with her on the panel for her relative's own interview, and that after the interview concluded, openly advocated for her relative's hire over a different candidate whom the complainant felt was more qualified and deserving of being hired. The complainant alleged that the administrator was actively aware of the HR director's familial conflict throughout the hiring process, yet permitted the HR director to actively participate in her relative's own interview. She also alleged that the administrator had a close personal relationship with the HR director and her family, which she contended also presented as a nepotism concern. Finally, the complainant alleged incompatibility of the proposed positions under the nepotism policy. Specifically, the complainant contended that the confidential assistant component of the proposed payroll supervisor confidential assistant position would report to the HR director, which, if accurate, would have put the alleged siblings in a direct reporting relationship. She also alleged that the payroll supervisor position may also be incompatible with the HR position, as it serves as an effective check on certain actions in the human resources function. I would caution that, again, these were mere allegations at the time, and we are here in a public session, yet many of the items under discussion are, in fact, allegations. Typically, allegations of this nature would not be discussed in public, but given the request of the employees, we are honoring the request in doing so. Pursuant to my obligations, I reviewed these allegations in light of applicable law. I also completed a follow-up conversation with the complainant the next day to verify certain contentions. Following my preliminary review, I determined that complainant's allegations on their face raised serious concerns under the manual's nepotism and conflict of interest policies, as well as the local government ethics law, NJSA 40A:9-22.1 et sec. First, with respect to the manual, the township's nepotism policy provides that family relatives shall not be hired where one relative would have the authority to appoint the other, 2, where one relative would be responsible for auditing the work of the other, or 3, where other circumstances exist that place the relatives in a situation of actual or reasonably foreseeable conflict of interest. Second, the manual's conflict of interest policy provides that a potential or actual conflict of interest occurs whenever an employee, including a township official, is in a position to influence a township decision that may result in a personal gain for the employee or an immediate relative, including certain close familial members, including in this current case. This policy requires that if there are any questions whether an action or proposed course of conduct would create a conflict of interest, the employee must immediately contact the township administrator to seek clarification. Third, the local government ethics law, again NJSA 40A:9-22.1 et sec, is a state law that governs all employees of the township and is also referenced and incorporated into the manual. In relevant part, Section 22.5C of the Act provides that no local government employee shall use or attempt to use his official position to secure unwarranted privileges or advantages for himself or others. Section 22.5D provides that no local government employee shall act in his official capacity in any matter where he, a member of his immediate family, or a business organization in which he has an interest, has a direct or indirect financial or personal involvement that might reasonably be expected to impair his objectivity or independence of judgment. Finally, Section 22.5E provides that no local government employee shall undertake any employment or service, whether compensated or not, which might reasonably be expected to prejudice his independence of judgment in the exercise of his official duties. Based upon the issues presented, I contacted the mayor. After various conferences that day, the mayor directed that the payroll supervisor confidential assistant be removed from any future township committee agenda as a remedial measure. During the course of our conversations, the mayor and I spoke with the administrator regarding the allegations. She confirmed her awareness that the HR director actively participated in her relative's own interview, and that the proposed hiring of the relative was never reviewed by Labor Council or any attorney as to potential nepotism. The night prior, the administrator had also recommended to the governing body that the relative be hired not only as the payroll supervisor confidential assistant, but also to serve as acting chief financial officer. The administrator wrote to the Township Committee that the relative, quote, agreed to step into the CFO role and expressed interest in this permanent position in the future, end quote. She advised the Township Committee that the relative previously served in the capacity as CFO in other municipalities, which appears inconsistent with her resume. During my conversation, the administrator inquired if the proposed promotion of the relative to the elevated acting CFO position would help extinguish the potential nepotism concerns relating to the alleged incompatibility between the payroll supervisor, confidential assistant, and HR director positions to allow the hire to move forward. Following these conversations, the administrator suspended complainant with pay. According to the administrator, this was done purportedly upon legal advice rendered by the Township's Labor Council. This aspect of the matter presents issues that remain subject to the attorney-client privilege and potential litigation privilege, and therefore any discussion on this aspect shall be reserved for an executive session. That evening, the Township Committee was advised of the relevant considerations pursuant to privileged communication. The Township Committee then scheduled an executive session to discuss the matter at its April 12, 2019 meeting, which was rescheduled to April 16, 2019. In accordance with law, the Township Attorney provided the Administrator and HR Director with rice notices. In response, both employees waived their right to have this matter discussed in executive session. It should be noted for the record that these specific rice notices were later rescinded. At the April 16, 2019 Township Committee meeting, the Township Committee did recess into executive session to discuss certain aspects of this matter relating to potential litigation in the attorney-client privilege as permitted by NJSA 10:4-12B7. The Township Committee expressly did not discuss any matters subject to the personnel exception, NJSA 10:4-12B8, and those matters are being discussed here for the first time pursuant to proper rice noticing. Returning to the rice notices, the HR Director wrote a response letter to the later rescinded rice notice, which was dated April 15, 2019, and was addressed to me in my official capacity as Township Attorney. It contained a narrative that provided the, quote, reasons for her request, end quote, that the matter be discussed in public session. The narrative went on to substantiate many of the allegations made by complainant. The HR Director stated that she and the Administrator were aware that the Finance Office was in need of a new employee with certain credentials. In response, she advised the Administrator that, quote, I don't know how you feel about it, but my relative may be available, end quote. She explained to me her relative's credentials, highlighting that she, quote, has over 20 years of experience in municipal finance, end quote, citing her past experiences and references and attaching her resume. The HR Director explained that she conducted interviews for the subject position with complainant. She wrote that complainant wanted to hire a candidate other than her relative to the position. The HR Director admits that she, quote, did go to complainant and ask her to reconsider because she felt that her relative was more qualified and I was concerned that the other candidate did not have the experience we needed, including payroll, end quote. She asked complainant to speak with her relative's references to, quote, learn more about her qualifications, end quote. Complainant offered to, quote, think about it, end quote, but later, quote, stuck with, end quote, her support for the other candidate. Regarding the current procedural posture, as stated earlier, the Personnel Handbook provides that, quote, employees who observe actions they believe to be workplace wrongdoing should immediately report the matter to their department head, the Township Administrator, the Human Resources Manager, or the Township Attorney, the latter of which took place by virtue of a phone call to me by complainant. The manual also provides that, following receipt of a complaint, quote, all reports of wrongdoing will be promptly investigated by a person who is not involved in the alleged wrongdoing, end quote. Strictly because this matter involves allegations in part against the Administrator, I was obligated to bring this matter directly to the attention of the governing body. In turn, the Township Committee directed the noticing of this special meeting in order to review this personnel matter further, which is the province of the committee. As you know, the governing body serves as the direct supervisor of the Administrator pursuant to Township Ordinance 2-5.4. It also possesses broad legal authority, including the executive responsibilities for the municipality pursuant to NJSA 48:63-6C, the authority to investigate any activity of the municipality pursuant to NJSA 48:63-6B4, and the power to remove any officer of the municipality other than those accepted by law for cause pursuant to NJSA 40A:63-6B5. Based upon these responsibilities and obligations, and in light of the facts presented, it is my continued recommendation that the Township Committee retain appropriate counsel to independently investigate the employment claims raised. At the direction of the Township Committee, tonight's agenda includes a resolution that I prepared appointing the law firm of Cleary, Giacobbe, Alfieri, and Jacobs, LLC, to conduct an independent investigation into certain employment claims. I believe that the Cleary law firm is well-versed in public sector labor law, and I would confer with the Township Committee completing this action to retain special counsel. I am happy to answer any questions that the committee may have on this matter, and would recommend that the committee also provide any direction to Mr. Sean Keane, who is present here from the Cleary law firm at this time, if it intends to move forward with his retainer.
Wow. So this is the first time we're seeing this. And we've had a flurry of, we did have a flurry of confidential emails that sparked this this tonight's meeting. I'm thankful our committeemen believe this should be investigated. So I believe right now there's a motion or there's a resolution to hire the law firm of Mr. Keane.
Yeah, similar, I'm hearing these for the first time in this level of detail as well. And would like to make the motion to adopt the resolution appointing Cleary, Giacobbe, Alfieri, and Jacobs, LLC as special labor counsel to conduct an independent investigation into the employment claims.
I'll second that.
So I have a question on that.
Sure, before we vote.
Curious, Mike, as to why you didn't feel the need to share this with the committee a little earlier today, so we would have time to at least digest it.
In truth, committeemen, I didn't know that I was intending to prepare this until I received notice this morning that the rice notices were being waived, and this is hot off the presses, so I was scrambling to get this completed for tonight. I felt it important to have this. I would have shared all these details orally and executive as I normally would, but in this case, I felt it important to have everything in writing so that, you know, no errors are made here in public in reciting anything. But otherwise, I absolutely would have gotten that to you sooner, Mr. Committeeman. Thank you. Is there any further discussion?
Mr. Bontempo?
Yes.
Mr. Vitale?
Just a question for Mr. Keane. I assume you've been brought up to speed on some of these matters prior to tonight?
I have not, just from what I was educated to when I heard counsel read the background on the information. All I really knew was that it was a labor matter involving some employees that were in a senior position in the town, but no specifics beyond that.
I was just wondering if this committee wanted to consider putting a cap on the fees, or are we just going to open it?
The resolution committee does cap them at $17,500,
17,500.
and that's a statutory number, yes.
Okay. I would vote yes.
Dr. Pascucci?
Well, yes.
Deputy Mayor Nicholas?
Yes.
Yeah, you got it. You voted.
I got it.
Yeah.
I started now.
Okay. So you want to, Mr. Keane,
Yes.
how do we move forward?
So, Deputy Mayor, thank you for the vote, and I look forward to working with the committee and getting to some resolution of some of the things that were raised in council's report. I would certainly ask for the authority to act independently from your municipal attorney, and part of that process would be asking Mr. Collins to provide us with the manual, personnel policies, any documents that would be relevant to some of the allegations that were raised. And typically what happens in these situations is, and if I could point out, our firm represents dozens, if not hundreds, of public entities statewide from Bergen County south, and we're labor counsel in dozens of municipal entities, not just municipalities, but water and sewer. We're labor attorneys for school boards, so we're very well versed in this type of a thing. And what we would do is we would conduct an intensive interview of the individuals that are involved. And what you do is you go forward, you get a story, you get a narrative, you come back after you put it all together, and we report to the governing body about what we found, and certainly the recommendations that would go along as well.
And how soon will you be able to begin this investigation?
Right away.
We can expect an expeditious investigation within weeks?
Absolutely.
Okay.
Counselor, a question. You're going to be as objective as possible, I'm sure, because I had a feeling there was some obstructionists up here. So I just need to be sure that you're going to be as independent and as, how can I say it, as diligent as you possibly can.
Yes, and absolutely, the facts are what they are, committeemen, and not knowing any of the individuals, quite frankly, I know some of the members of the governing body certainly, but I do not have any connection with any of the members that are involved in Mr. Collins' report here tonight. So, you know, we have a reputation and we do a good job, and we're going to get to the bottom of it. We're going to present to you what our findings are, and it is what it is.
One of the things that kind of led into tonight was the challenge of getting this meeting scheduled and properly noticed. It appeared to me, and I don't know if the other members feel the same way, that it was almost an attempt to prevent this meeting from happening tonight, which concerns me greatly. And I want to be concerned, as Committeeman just mentioned, that you have access to whatever information you need to properly run this investigation. And open for, since we are not in executive session, in comments from ideas in which we can help ensure that this thing moves as expeditiously as possible, plus you're not confronted with any issues you have to come back to us for additional intervention on our part.
Understood, and if I may, if I do sense that any of that is happening, I can pledge to you that I would immediately report it to this body, but I think that things should be working a little bit differently. If that happens, I would be very upfront about that.
And Mr. King, who would you be reporting to? Just the governing body, the attorney? How does that work?
To everybody, all the members of the governing body.
So your communications to us will be jointly or individually? I mean, will you be reporting directly to the mayor, or will you be communicating to all of us via email and asking for public meetings or executive session meetings?
So after we are now authorized tonight in our law firm to start the process, we will be setting up interviews, reviewing certainly the manual and some of the items that were raised in the report. And it would be an independent investigation, if you will, or exercise until such time that we conclude it and we come up with our findings and recommendations, and then it would be a joint presentation. And we could do that in executive session, or if the employees choose to waive that, then certainly it would be something that would be done in open session, just like we heard here tonight. It wouldn't be any piecemeal things with me reporting to you one night, and it would be something that at the end of the...
It wouldn't be anything like the Mueller investigation, right? I mean, it's like I'm on for 2 years and you're not, okay.
It's not going to be 30 million.
And I would note that I think it's great that Mr. Keene is looking to communicate directly with the committee. I think that's the purpose of an independent investigation. And in fact, I obviously, I've prepared the report based upon a complaint that was made with me. So I actually am, a witness to, in a sense. So that's the virtue of having someone independent looking at it. I'll certainly be providing his office with whatever he needs, but I know that he'll, be independently handling things, and, that's the right way that things should go, independently.
So I guess I have one other question. Again, you read it for the first time or heard it for the first time, as we all did. Do you believe that you may be interviewing the former employee? Or you can't say at this point?
I honestly don't know. I would have to review everything, and by the way, the process could require that we do have a meeting where we get together and we say, hey, we're still in the middle of this. We haven't concluded our investigation. And, we being special counsel, we would ask for special meetings so that we could maybe glean more information or talk about additional items. And that forum, again, would either be an executive session, or because we're talking about individuals, would have to be an open session. But at this juncture, I just don't know what's before us, so I can't really intelligently answer that. It's possible.
Understood. Counselor,
I have a question. I mean, I want this to go as smoothly as possible, and I'm not a lawyer, I don't know all the details, but should these two employees be working with us for now? I don't want anyone to give in, I don't want this investigation to be obstructed in any way. So maybe if we could put them on some kind of leave and pay them for a couple weeks till we get this done.
I quite honestly wouldn't be in a position to make a recommendation. I think that would be up to your municipal attorney to do that.
Is that something we could do?
Well,
Yeah,
yeah, I mean, I guess if Sean, I mean,
that's something
you called me
I called
this
morning
afternoon,
and asked
Committeeman.
yes.
I guess the long and short of it is, I reviewed it with the labor attorneys in my office, and it is within the province of the committee that if you wanted to, if you felt it appropriate to ensure the integrity of the investigation and to maintain order and effective direction of the township environment, that you could potentially suspend with pay. That way, any affected employees are not negatively impacted financially in any way. And then that would allow the investigation to move forward to address Dr. Vescucci's concern. That is an action that the committee could choose to take in its executive responsibilities if it chooses to. But that's, subject to your discretion. And
this is not prejudging anyone, this is with pay. But I just think it might make a smoother
I
investigation.
think pending the outcome of the investigation, I think it's a wise move. I'd make that motion that we.
I totally disagree with that. You're assuming someone's guilty of things that they're being
have a lot of
investigated
email.
for properly.
It didn't say that.
It didn't say that.
Let me finish. I haven't cut anybody off tonight, and I don't expect to be cut off by you gentlemen. I think you have to take into consideration how this is going to impact all of the employees here in this building and the ones that work for the township that aren't housed in this building. It's a morale issue if you're taking leadership and putting them on the bench. So I totally disagree with that. I think the three of you are going down a path that's a mistake. And I'm just going on the record for that. I think you should strongly consider allowing the town to run as effectively as it's being operated under the leadership of Donna Vieira, and then let the councilor do his job. And if at some point in time he feels he's being obstructed or he can't effectively do his investigation, by all means, we may consider further action. But I caution you to take that action at this time.
Thank you, Mr.
Thank you
Kelly.
for your comment.
Thank you. So I'm going to move forward with that.
If you are going to make a motion,
Yes.
Committeeman, I would note, if you wanted to, I have a resolution I can word for this, but there are some issues that you need to lay out for me what exactly you're proposing, and if there are any suspensions who you would be proposing to act as an interim. I mean, you can't just, we can't just make a motion, we have to figure out terms
That's
that
fair.
you're proposing.
That's fair.
So I think to be consistent would be both employees who were impacted. And then the question I had for you is, Counselor, is we have not been served yet, but if we are served papers, does that change anything with your investigation?
I would caution that I think that would be subject to attorney-client privilege. I think that's legal advice regarding potential litigation that we could enter into an executive session tonight if we wanted to discuss aspects such as that.
So your question is who, if we move forward with this, who would be the interim administrator? Is that what your question is?
That's one of them, yes.
Okay, so what other questions are there?
I guess at your request, Deputy Mayor, I prepared this resolution, perhaps we share it with the governing body, and you can kind of determine if these terms are something you want to mark up. I mean, just
Mike, could you read this to the public since we're in public session?
we certainly can.
If the deputy mayor asked you to work on this today, I think the public has a right to listen to it.
Absolutely.
Thank you.
Deputy Mayor, would you like me to read the resolution? Sure. Okay. And again, this was a draft that the Deputy Mayor requested with respect to his concern about potentially a suspension with pay. So this is for the committee's consideration if you choose to move forward. A resolution suspending Township Administrator and Township Human Resources Officer with pay pending the outcome of an independent investigation. Whereas pursuant to NJSA 40A:63-6C, the executive responsibilities of the Township of Holmdel are vested in the Township Committee unless otherwise provided in general law. And whereas pursuant to NJSA 40A:63-6B4, the Township Committee of the Township of Holmdel is authorized to investigate any activity of the municipality. And whereas pursuant to NJSA 40A:63-6B5, the Township Committee of the Township of Holmdel is authorized to remove any officer of the municipality other than those accepted by law for cause. And whereas pursuant to Holmdel Township Ordinance 2-5.4, the Township Committee of the Township of Holmdel is responsible for the review and assessment of the Township Administrator. And whereas pursuant to Holmdel Township Ordinance 2-5.6, the Township Committee of the Township of Holmdel is authorized to appoint another employee or officer of the Township to temporarily perform the duties of the Township Administrator due to absence or disability of the Township Administrator. And whereas based upon the foregoing authority and accompanying responsibilities, the Township Committee has hired, authorized, and directed Special Labor Counsel to conduct an independent investigation into certain employment claims pursuant to duly adopted resolution at this meeting of the Township Committee of the Township of Holmdel. And whereas in order to ensure the integrity of this investigatory process and maintain order and effective direction of Township services during the pendency of same, and pursuant to its foregoing authority, the Township Committee of the Township of Holmdel deems it appropriate and necessary to take certain personnel actions pending the completion of the foregoing independent investigation. Now therefore be it resolved by the Township Committee of the Township of Holmdel as follows. 1. Township Administrator is hereby suspended with pay. 2. Township Human Resources Director is hereby suspended with pay. 3. The individual you choose to appoint is hereby appointed as acting Township Administrator in addition to his or her position as their current position, and you would set the compensation. 4. The Township Attorney is hereby authorized and directed to take any and all steps reasonably necessary to effectuate the foregoing terms. 5. The provisions of this resolution shall remain in effect unless and until further action is taken by duly adopted resolution of the Township Committee. 6. If any section, subsection, or paragraph of this resolution be declared unconstitutional, invalid, or inoperative, in whole or in part, by a court of competent jurisdiction, such chapter, section, subchapter, or paragraph shall, to the extent that it is not held unconstitutional, invalid, or inoperative, remain in full force and effect, and shall not affect the remainder of this resolution, and this resolution shall take effect immediately.
All right, so I guess,
So as a backup, the chief of police will serve as administrator.
okay. And then for,
Have you spoken to the chief about that?
Yes.
and
For proposed compensation, if you have an individual in mind, given the chief, I would recommend that compensation be set at the low end of the range for the administrator if you were to proceed. That way it's legal within the salary ordinance, and he could be compensated for the two titles if he chose to do that.
He was acting when we had a vacancy, when Katz was our administrator, and I don't know what, maybe there was a precedent set that we could look
Okay.
at. I don't know what it was.
And it's happened even before when I was on the township the last time when the chief did it. I just wish I saw this sooner too.
I apologize. I mean, today was a whirlwind. I first got the email this morning.
It's similar to
and-
what I'm thinking, but I just wish I saw it. And if the police chief is willing to do it, I think he can do it, and I'm pretty okay with this.
all right,
And again, there's no, I'm not saying anyone did anything wrong.
I believe that,
And I want to reiterate that to Dr. Pascucci because I made that point at the opening of my remarks. This is a very unusual situation where we're discussing allegations. And I don't like discussing allegations in this setting. I think it's very uncomfortable. I think it's not good for the, to have these things aired because they are not substantiated. But I also respect the right of the employees, and New Jersey law provides them this right. And as a committee, the only way for this committee to do its work while respecting and following state law is to abide by the employee's request to have this in public. So, this is a necessary procedure we're following, but I do want to caution, again, these are allegations, and everything recited is nothing tonight. No decisions were made or anything. In fact, the reason why you have an independent investigation is to determine what the facts really are. It's entirely possible that a lot of the allegations that were provided are false, and if that were the case, then I'm sure the matter would clear up rather quickly. But I do want to caution that to everyone. It's obviously these topics are always difficult, personnel matters, but the governing body is operating within the confines of state law here and having a difficult conversation.
thank you, Mike. So there's a motion to move forward with this
I'd like to
resolution?
make a motion to move forward with police
Police
chief.
chief, okay.
All right, so for paragraph 3 of the resolution, Chief John Matichewski will be appointed as acting township administrator. In addition to his position as chief of police, I'm going to offer an amendment that he be compensated at the base of the salary range of the township administrator to the extent feasible under applicable law during the pendency of this appointment.
Okay, so there's this motion, second.
A second.
Okay.
And maybe if we weren't discussing this in public, I'd have a different view, but now that this has been discussed amongst us in the public, I'm not sure that keeping the employees in place is going to benefit, from my perspective, the employees and morale when these allegations. But once they're hopefully cleared up, we can certainly look to, make other actions at that time. So we vote?
Mr. Bontempo?
Yes.
Mr. Vitale?
So Dr. Pascucci, you've said to me a number of times, and I'll quote, I love Donna. I love Donna Vieira.
Yes.
So I
Am
just
I
hope.
doing this?
No, I'm just making a statement. I know how you're gonna vote. The vote is in. But my fear is, by taking this action, we will lose the most effective business administrator this town has ever had. Committeeman Bontempo and I interviewed her 6 years ago. Mike and yourself were not on the committee at the time. I believe she's done a fantastic job, and if there were some mistakes made, we will uncover them. Council will uncover them, and there'll be a report to all of us probably within the next 30 days. But by suspending her, I believe there's a highly likely chance that this woman is going to walk out on us, and you have done a huge disservice to the residents of this town, in my opinion. I hope I'm wrong, but I've been doing this now for 6.5 years, and I think we're making a huge mistake tonight. And it's obvious that things have been done over the last several days, and I do not believe what you said, Mr. Bontempo, that if this was not in public, you would have acted differently. I believe you're being a little vague in that regard. That's just my opinion. Obviously, I vote no to this motion.
I get to speak too, my turn?
Dr. Pascucci?
Now I give my little speech. I do like Donna, but she's certainly not perfect. And I can talk about her in public. Certainly, I ran my own business, and the actions that I heard tonight, are you kidding me? Education needs to be drummed down their throats. Actions were taken here. I know we're going to get a private investigation here, but actions were taken here that if it was my business, they'd be out. This is unacceptable behavior. I'm not saying they did it for an evil purpose, but they don't have correct knowledge at least. So I might like Donna, but I left my country, but it's not perfect. And she's not perfect, and I have to protect the residents of the town. And I think this thing has to be followed through. And I think the two people in question should be out of the situation while we're getting this done. I truly believe it. And if Donna wants to walk, let her walk. I mean, I would love her to stay. You know how I feel about her. But that's her thing, and I think she has to have big enough gonads to stay in place. Gonads. I vote to support this resolution.
Deputy Mayor Nichols?
So for the record, I never wanted to have this meeting in public, but for the record, we have not had an executive session since January. I wish we could have had this behind closed doors upstairs, but the rights notice is properly done. Unfortunately, we have not had executive session, so I vote yes.
Business from the committee?
Yes, just real quick. I don't know if this is the proper time for it. I just want to remind the committee that there's a Holmdel Township Ordinance 2-3.1. I'd like to make the motion that we reinstate the meetings on May 14th and 28th, the 28th of May, that were improperly canceled without resolution of the governing body.
So, just so I understand,
This town is off the rails.
meetings, once they're set in January, can only be canceled by resolutions. Is that accurate?
All right, I think it's fair to say that, historically, dates have been set and rescheduled based upon general availability of the committee, and it's been done in a cooperative manner. To the extent that environment may not be there, I do pull the ordinance. The ordinance does indicate that the original meeting dates that are set in January are amended by resolution, so it would be my advice that if you choose to set a meeting date here by resolution, that would be acceptable. That's your desire.
I have a question. A resolution in public, or is it like?
I mean, a resolution is an action in public of the governing body, yeah. So if you're making a motion.
Yes, my motion is to reinstate the May 14th and May 28th meetings.
Okay.
I'm just going on the record, I'm out of town on the 14th, I'm in Florida on vacation, so I won't be here. That may have been one of the reasons why the mayor chose. I can't speak for him, but I know I won't be here next.
Yeah. I wasn't queried on them, so I didn't have any input. Did you?
I could have input that if I wouldn't mind, and since I'm retired, guys, I really don't mind. But if that's the rule,
You good for the 14th and 28th?
I'm good for any date. I'm good for the 14th and the 28th. I think the more meetings, the better. I think we need that meeting.
Especially now.
Yeah,
Is your second?
on a second,
Okay.
if it's legal.
Mr. Bontempo?
Yes.
Mr. Catali?
I guess, I won't be at the first one, but yes.
Dr. Pascucci?
Yes.
Deputy Mayor Nicholas?
Yes. Any other comments from the committee? Mr. Kelly?
Comments? Business from the committee?
Yes. Anything else?
No report.
No report. Dr. Pascucci?
No report.
Mr. Bontempo?
No report.
All right, my favorite time of the night. Public comments. Mr. Yanello, come on down. Just remember to state your name and address.
J. 18 Lavender Drive. I would just like to simply say that the degree to which this town is off the rails since this January, including the $2 million consent agenda item for the turf field and towers at the swim club, and now all this other stuff, is appalling and shocking. And I hope this gentleman gets to the bottom of what's going on, and possibly any other stuff that needs to be cleaned up. This is an embarrassment to the residents, to Monmouth County, and this town needs to get back on the rails. This is appalling. Thank you.
Thank you. Anyone else?
Jackie, we're all upset as well, but please don't break the equipment.
Name and address.
Kathy Weber, 4 Duncan Drive. I just want to ask, I don't know if council can answer this, but will this investigation include township emails between any of the parties concerned as well as any of the governing body, and will the outside counsel have access to that?
My guidance to the independent counsel would be anything that he believes is an appropriate material for him to review, he should have access to. And as township attorney, I would facilitate it that way.
Okay. And would this investigation include any other filed ethics complaints that may be filed with the state or other entities?
No, I think the committee provided direction tonight on what will be reviewed.
So those would not be part of the scope of this investigation?
I'm not even aware of what you're referencing in terms of anything in the
I am aware that there have been ethics complaints filed with the local finance board.
Okay.
I could have put, they're gonna be made public, or that's a private thing?
That's up to the regulations, I believe. I don't want to speculate on what the regulations say at the local finance board.
They are public when they complete their findings. Thank you.
Thank you.
Thank you. Next. Ms. Brew?
Debbie Brew, 15 Cindy Lane. I have a statement to read. On January 11th, I received a conditional offer of employment for a job in the township. The letter indicated all of the conditions, which included a background investigation, pre-employment, physical, and drug screen. I passed all of these as well as any other conditions. And the last condition was approval of the Township Committee, which was to take place on January 23rd, 2018. My start date indicated on the letter was to be no sooner than January 29th, 2018. The job was deliberately not included on the January 23rd or the February 13th agenda due to curious circumstances. On February 15th, I received a FedEx letter indicating my job offer had lapsed due to lack of approval by the Township Committee. There was no expiration date on my offer. Since special counsel has been hired to look into hiring practices or matters where the township is concerned, I would like the improper conduct of the entire Township Committee regarding all hiring practices considered, including mine. I have here my Oprah request, which resulted in 528 pages of communication regarding the job I applied for, interviewed in 2 departments for, and was formally offered. Included in the findings are approximately 50 pages from Serena DeMasso to certain individual TC members, but not to all, with regard to my position, which the body of most of those emails were redacted, although they certainly did not include social security numbers or any reason for redaction. When I asked Mr. Collins why it was redacted, he answered attorney-client privilege. Interesting, who is the client? I will, and I intend to handle my own matter. My point here is, let's not play favorites. Let's not be hypocritical. Let's look into all the faults of all involved in hiring practices. I was offered the job because I earned and deserved it and was qualified. It was never added to the agenda because of many reasons, including threats to TC members by those not on this TC, which were made public. I also was personally told by one TC member that because I didn't support him in a previous election, he wouldn't put it through. I was told by another he hated the township administrator and would never approve it. I didn't understand this excuse as it had nothing to do with me. These comments did not include Mr. Bontempo, Mr. Vitelli, or Mr. Hines. There are many personal agendas and egos going on here, but all roads lead back to one person. And until you start standing up for yourselves and do your job yourselves, this chaos will continue. You should be embarrassed spending money on legal counsel when no one was fired. Someone left because they found a better job. If you are really going to look into hiring practices and personnel matters, look at all of them.
Thank you. Anyone else? Mr. Blumenthal?
Good evening, Ralph Blumenthal, 41 Stony Brook Road. With regard to the last item you talked about, which was the dates for the meetings, the rescinding that cancellation notice, so now you have meetings on for the 14th and 28th. That cancellation notice also said there'd be a meeting on the 21st, I believe. Is that on or off?
We'll send an update. It'll be publicly noticed.
Which is the
It's the 14th,
or off?
the 14th and the 28th are the dates that were originally set.
Okay, so the 21st is off.
The budget's very important, so we have to talk about the budget. We'll publicly notice.
21st.
21st, that's why I didn't want to.
My advice to the committee would be that we need a meeting on the 21st because the budget timeline with the advertising requirements, the statutes are rather particular, and I think Wendy already noticed it.
So yeah, 3 meetings.
Is the 21st already noticed,
Yes.
Wendy?
Yes.
And
I did the 14th and the 28th were canceled, and the 21st was scheduled.
are there any issues with the committee having the 21st meetings that we get this budget passed?
I have no
Doesn't
objection.
matter for me.
Great.
So, okay, so 21st is still on, and it's going to be the budget.
That's right.
Okay.
I wasn't even looking at my calendar, so this is news to me, so I guess we'll see a lot of each other if this is what we're doing.
Okay. Just a couple of questions then with regard to the item you spent most of the evening on. Obviously, it's a difficult and complex thing, and I appreciate hearing you talk about it and try to find a way forward for the sake of the town. And best wishes, I don't know if that's the right word, for the independent counsel to appropriately, independently determine what are the appropriate facts so that we can act on it. I did a couple of questions. The resolution, which did appear this afternoon on the Township website that you adopted, does say that whereas the Township Committee desires to award the contract to Cleary, etc., upon the terms set forth in the attached document. The implication is that that firm made a proposal to the Township that was not here attached. Is that now public?
No, you know what, Ralph, that was my error, and I will attach it and put it with it. I have it with theirs, and I forgot to do it on the website, so I'll correct that.
Okay, so that becomes a public document.
It is a public document.
Yep, I'll put it on there
Okay.
tomorrow morning, first thing.
It has the rates.
Fine. Then, how was this particular firm selected? Was there a process, or what can you say about that? I don't happen to know you, but that doesn't mean good or bad.
That's a good question, because I didn't find out about it until probably today myself, so maybe the deputy mayor can answer that question.
They're already on our, we don't have to go out for outside counsel, they're already on our list of attorneys.
And Ralph, this was not the first time we talked about it. We talked about it in private session last time, about how we were going to select an attorney, but that was private session. This is now public.
Right, okay, so there was a process, they were fine. Okay, and then lastly, the document that you prepared today, Mr. Collins, is that now also available publicly? There was a lot of I use your word, there were a lot of allegations in that. But it would be, I think.
I will review if there is a request, whether or not. It's an interesting situation because it is an attorney-client privilege document, but the privilege may in fact be waived by virtue of the employee's action. So if you file a request, I'll certainly review that, but obviously the recording is public record, so this is all common knowledge. So I don't really see the issue.
You made a lot of statements.
Understood.
And I think it would be appropriate for the public to hear the whole story.
I want to caution you there and caution everyone, that is not the whole story. Everything I said is a fraction of the story, and in fact, and that's why I'm so cautious, and I really am uncomfortable with the nature of this, even though this is the process we have to follow. But I duly noted on what you're saying, and I think that's totally fine. But again, I want to reiterate, and it's not because you said anything specific, Ralph, but everything was based upon a complaint that was filed, which is typical employee process following a personnel handbook. An employee makes a claim, there's a process, and the process in this case is involving an independent investigation. It just so happened that the employees in question requested that this be discussed in public, so that's kind of why we're in this situation. Otherwise, this would be discussed in executive, which is much more routine, and that's to protect the employees from having this discussed publicly, but this is their right to be in this forum.
Thank you.
Thanks,
Thank
Ralph.
you all.
Anyone else? Barbara?
Barbara Singer, 5 Deerfield Road. When was the last time we had to hire outside counsel over a personnel issue?
I mean, we could certainly take a look at the bills, but I mean, I will just say overall, not speaking specific to the municipality, but it's a fairly common occurrence for labor counsel to be engaged in, an issue where, there's an employee complaint that's raised. It's, a required process to be followed. So I don't see anything that's that abnormal about this action.
What does that mean to us who is not involved all the time, once a year, once every 5 years? How often are we retaining outside counsel to do an internal investigation?
Well, I'll jump in here and say that in the 6.5 years that I've been here, I think there's been a few instances where the police chief has had to use our labor counsel to do a review and get some guidance. As far as an internal investigation for, whatever language you just used, this is unusual.
Yes, using it. So we do have our own labor attorney. Why is that attorney not being used in this situation?
I think in this situation, I believe it's because our current labor counsel is conflicted in this issue, so we had to use another. Normally we would use one, but we can't because of a conflict of interest.
Okay, and where can we find the list you said that we have of outside counsel?
It was approved in January. List of all the
It was
defendants
approved in January, the
Yes.
outside counsel list?
Yeah.
Okay. Just procedurally, Mr. Collins, I noticed that the notice for this meeting tonight was signed by you and not our clerk. Is there a reason why that?
Sure. The notice for this meeting was at the election of members of the committee, and because the clerk was unfortunately ill on Friday, in order to effectuate the will of the committee, I noticed the meeting from my office directly.
Okay. And then just another comment. We were having a public meeting, so, and everyone's indicating here from Mr. Collins, to Mr. Bontempo, and I think Mr. Nicholas, that a lot more has gone on behind the scenes. So it seems that this meeting has not been fully public or transparent. We were talking about confidential emails that went back and forth today. Obviously, a lot of work has gone on to have these resolutions prepared for tonight. So there's been a lot done behind the scenes when the whole purpose of this and request of the employees was to have this done in public. And I understand it's not comfortable, but that doesn't negate their request or your obligations.
If I could, would you like a response on that, Barbara?
Sure.
I mean, the committee has an obligation to carry out its executive functions, whether there's a meeting on a certain night or in the intervening period between meetings. You know, if there's an issue of concern, if there's a fire in town, the administrator is contacting the committee via email. In this case, I referenced, you know, a privileged communication, which would come from counsel to the committee providing attorney-client privilege information. That is routine, and that is how a township runs. And so I think it's very unfair to characterize the due diligence by the township's professionals and employees in addressing this matter in the intervening period between meetings as somehow not being transparent. I mean, I think the conversation tonight was about as thorough as you'll ever see with respect to an item of this nature. So I just don't understand where you'd be making that characterization from.
So you had a motion, everyone voted yes on this initial motion, and there was no discussion. We heard the statement you read. There was not discussion amongst yourselves before the vote, and I think that's where there was a lack of transparency. We didn't get to hear from each of you addressing anything that was in the statement that Mr. Collins read, and you yourself said there was a lot more to this that wasn't in the statement.
Well,
so that's
there's
just
also
where
pending and
anticipated.
I'm
also
finished.
right.
I'm hearing from your own mouth that a lot went on that is not being spoken about. So
Okay.
that's my comment.
Okay, thank you. I would just respond for everyone's benefit that, like the deputy mayor just mentioned, there was previously an executive session on the aspects that involve attorney-client privilege and potential litigation that can be discussed in executive, and the committee rightfully discussed that in executive because it can't be discussed in public. And with respect to a personnel appointment, that is a potential contract engagement, which would also be subject to executive session privilege. So there's no grand conspiracy. The committee's following state law, and I think the committee did an admirable job of dealing with a difficult issue tonight.
Okay, you're doing very well complimenting yourselves. But my point is, I didn't say there was a grand conspiracy. I said there was a motion with a lack of discussion when the point of this was to be an open public meeting.
Thank
That
you.
was all I said. Don't
Thank you, Barbara.
mischaracterize what I said. Thank you.
Thank you so much.
Anybody else? Yes.
Good evening, Randy Rauscher, 36 Blue Hills Drive. A few moments ago, somebody made a comment, I forget who said it, that it sounded like there were regrets that we have had no executive sessions since January, I think was the statement. Is that, why is that, and who makes that decision that there won't be?
The mayor sets the agenda. I don't have an answer for you.
Anybody else have a?
No, I think what he said was correct. We don't set the agenda.
Okay, so Councilor Mayor.
We're a committee form of government, right? So we all are equal in terms of our voting authorities. There's no strong mayor. Like you elect the mayor, and all five of us are up here, we're all equal in what we vote, right? 3 votes can determine, you know, a decision or adopt a resolution. The mayor, in addition to that, the mayor sets the agenda with the administrator. So I can't, the administrator's not here, the mayor's not here, so I can't answer, but that'd be better addressed to them when they.
All right, thank you.
Anyone else? Yes.
Ken G, 8 State Street. I know this is very difficult, but I want to thank Deputy Mayor and the Township Committee. This is not an easy topic, and I realize part of it is driven by the waiver of the rights notice and all that, but anytime you have a complaint, allegation of things, for you guys to step up and go forward with an investigation, independent investigation, is kudos to you guys, because there is an obligation you guys have to do. It's not an easy, uncomfortable position. I understand that. I have been in positions where finance department, HR department report to me, so I understand exactly what you guys are going through. And it's possible that at the end of this investigation, everything's clear. It may be something else, who the hell knows, but it's a process you guys have to go through. The fact that you guys are willing to step up and do this and do it in public, so my hats off to you guys for doing that. We'll see where the investigation goes. Who the hell knows? Right? It could be all clear, and hopefully in a short time, but maybe not. But the process has to be done no matter what. So thank you.
Thank you. Anyone else from the public? Going once, twice? Motion to adjourn?
Motion.
Second.
Good night, everybody.
Good night, thank you.